prominent attorney Shaw Pirelli for the Shaw Pirelli Law Show, coming at you with over 50,000 watts of power. The Shaw Pirelli Law Show, where all your views matter.
Hello, everybody. Assalamu alaikum. Sastikan namaskar to all the listeners. This is Attorney Shah Pirelli for the Shah Pirelli Law Show, and today we're going to discuss, of course, about immigration law and also debt settlement. But before I start, anything I'm telling you today is purely informational. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. We will take the calls in a few minutes, Michael. I know we're already having a bunch of calls. 510-657-1170. That's the number to the studio, and the number to our office, 510-742-5887. 510-742-5887, and the number to the studio, 510-657-1170. To start the show, bad news again. The visa bulletin for 2018 September retrogressed on EB2 badly. Unfortunately, that was my fear, but we were hoping, seeing always a movement in the past few months. Now we have a retrogression going back to 2007 on EB2 category, and that's kind of going to hurt a lot of people because a lot were expecting. And now EB3 also moved from 2009 suddenly back to 2003. And that's really another painful situation we're going to face for India. And as for EB1, it's still 2012. It seems like it's still 2012 January. But this is really bad news, and I hope things will get moving after a while. But that retrogression is really going to hurt a lot of people. So at the end of the day, we are going to talk a little bit about the visa bulletin and what's going on, if there will be some changes possibly happening. But before I do that, let me take a few callers. I think, Michael, they have been waiting. Let me take one caller right now. This is right, you're live in air. Hello?
Hello? Yes, hi. I have a question. So I'm applying for my parents for their green card, and so for one of my parents, for their birth certificate, we have her, and in there, the name of her parents is in short, as in A.B. last name. So will that birth certificate be accepted, or we need any other evidence? And also, it was registered this year.
Okay, then.
And I had another question about from other parent for the non-availability. We got it from a municipality. Would that work, or does it need to come from the registrar of birth and death?
Okay, let me answer one by one. Number one, it is a late birth certificate anyway, so you will need two affidavits and other secondary proof to prove the name and the birth date. So you can put school records, get two affidavits from people who are a little bit older, who can basically testify they were born on that day and that place. And plus, you can put like medical records and all the stuff.
So we have only the affidavit. Would the affidavit just work?
Yeah, but I would recommend putting more stuff. If you can get some other stuff. If you can, just use the affidavit. But the problem is that just the affidavit might not be not enough. And now with the problem that they are not taking, they might not issue RFEs, you might just see yourself with a denial. So I would recommend, if you can get more stuff, to put it in there, and if you need help, you can give me a call at the office. We can help.
More like you mean like hospital record or something? Like what else can we get?
Well, I cannot give you the list in the radio show because it's a long list. Anything that proves their date of birth, like school record, medical record, ration card, you name it, you can put all this. And then
it should have the full name.
Oh, yeah, it has to have their name in there and their date of birth. Because right now, not only the name is a problem. What you got is called a late birth certificate. It's considered as a secondary evidence. It's not considered as primary birth certificate. And the second issue you are having you will have to get the place where usually they issue the birth certificate. This is where you have to get the non-availability certificate. So just go ahead and get those and then put it there. And if you need help, just give us a call, 510-742-5887. But anything that you can put in there, you can. I think I have a YouTube video on that on my YouTube channel, youtube.com/Shapirali Just check it in there, search it. It might be there. All the checklist is there. Okay. Good luck to you.
Right. Okay. So just to confirm, then, I mean, is it needed to do from registrar or not needed always, right?
It all depends what the local law is there. If your birth certificate is supposed to be issued by the registrar, then you have to get it from the registrar. So it depends on the state and the place where you are. So I don't know.
Right, but would they accept from municipality? I mean, the question is, would they accept from the municipality?
I don't know, because it all depends on the place. If usually the birth certificate comes from another from the municipality, then yes. If it doesn't, then it doesn't have value. So it depends on the state. So if the state issues their birth certificate through the municipality, then yes. If not, then it has to come from the registrar office. Okay?
And you mentioned your youtube.com/ what's the name, the channel?
Shapirali Law, SHAPERALLYLLAW. Shapirali Law. youtube.com/Shapirali Law. Just, I think there's a video I made on that. Okay? Okay.
Thank you very much.
Good luck. Yep. Good luck to you. Let me take another caller. Hello, Prakash?
Yeah. Hi, Shah.
Yes,
Thanks
sir.
for
Go ahead.
taking the call.
Hi, how are you?
My question is related to I-751. My application has been pending for almost 22 months now, and I'm almost 2 months beyond the current processing time for that date. I submitted a service request, and they sent a note back saying they had to do some additional processing, and the application is currently with the adjudicating officer and wait for 60 days. I was thinking if I should continue waiting or go ahead and apply for my citizenship, because I didn't want to have
you can do both. It all depends on your case. If your case, you're married, you're strong, you have a lot of evidence, then go ahead with your citizenship. Otherwise, I recommend get your I-751 passed, get your final green card, then file for your citizenship. It all depends on it's a case by case. So, for example, if you have a lot of proof of your marriage, like, for example, you have children together, house together, bills together, then, yeah, go ahead. But if you don't have a lot of things, then it's better to pass the I-751 and then file it. And, in fact, then I tell people if they don't have a lot of proof to always make sure you do it on the 5 years. Because if you do it based on the 3 years for citizenship, what it does to you, you will have to reprove the marriage at the citizenship interview. So it all depends on your case. If you have enough proof of your marriage, you have children together, etc., then go ahead and apply for the citizenship. But until the I-751 is cleared, they are not going to consider the citizenship. But it is done. I've done it.
So if I apply for N400 now, will my 751 be put on hold until the N400 is processed?
No, it's the other way around. They will put the N400 on hold until the I-751 is processed. But it used to be a problem because the files were physical, printed, and then by the time the file changed hands, it delays both of them. But now, since everything is pretty much electronic, you might not have any issue on that. So I will go ahead and basically you can check which one. Then it all depends on your case. Okay.
And based on your experience, do you know why a case would be pending for so long? I mean, all other applications looking in the forums for the month in which I applied, they have been processed or approved. but I've neither received RFPs nor any kind of feedback.
That's a very good question on I-751 you're asking. There are three reasons. Number one, it might be they are not satisfied with the proof you have sent. Number two, the case is going for an interview, so they are sending it to the adjudicator field's office to do an interview for you. And number three, you might be either a background check or a random check.
Sorry, what's the second one? Background check?
Background check. That means basically they want to do a background check on you, check if you are a terrorist and things like that. So that's something that's done by a different department, and that takes time. Or the fourth reason
I think it's the third one, because I've submitted more than enough proof, and all other, even those applications that were sent for interviews for my month, they have already received their interview notices long time back.
Yeah, it might be. Then it's probably either a random check or a background check is usually the most delay. But what you can do, you did a service request on that, right?
Yeah, and they replied and said it should be processed within 60 days, and it's been about 40 days now.
Okay. Just wait on that, and then I have cases, even in the past, I had cases which took 8 years. So it's not it's not abnormal, but most of the time it's taking like 24 months right now. Okay?
Okay. So even if with background checks, it shouldn't take more than 24 months.
Well, the problem with background check, if it pulls out to be one of their check, then the delay is unpredictable. That's the problem, and that's what happened in that case that took 8 years or so, because they were doing extensive background check. And now with the new administration, they are trying to do this on pretty much everything. Okay?
Okay, thank you very much.
Good luck to you. Good luck. So, ladies and gentlemen, I don't know if I have more callers, but I have to. If people want to call the number to the studio today, 510-657-1170. 510-657-1170, and we are talking about cases where people are the visa bulletin, right? The visa bulletin, which is a big bad news right now, especially for EB2 category, employment base. The September visa bulletin is 2 years backward. We didn't have a retrogression for a long time, and suddenly it just hit us with a retrogression on EB2, and EB3 went back almost 6 years. This is kind of going to really kind of get people upset. For those who were lucky to get it on the EB3 now, we are talking about another long wait time on the EB3, and people are going to start moving back to EB2. As for EB1, it's pretty much stayed the same. It's still 2012. So for those who have a potential for an EB1, take it, because you can still take your priority date from EB3 or EB2 and bring it here. And last week we had a very good discussion on EB1, EB1A, especially with Sharif. And if you get a chance to listen to that podcast, it's on my YouTube channel, youtube.com/Shah Law. And please check it, because that might give you a lot of good stuff that you can use pretty much for possibilities of moving forward. So having said that, now I think, Michael, I didn't understand. Okay, we don't have any callers right now, so you can still call 510-657-1170. 510-657-1170, the number to the studio, and of course the number to our office, 510-742-5887. 510-742-5887. And you can check our website, piralilaw.com or attorneyonair.com. It will go on the same website, attorneyonair.com, that's a one word, and that will bring you to our website. So today, of course, suddenly we got hit by this visa bulletin. We have a lot of bad news also. It seems like it's becoming the norm now. The bad news are coming one after the other. One of the things we are seeing for those who file new H-1Bs, we are getting those those RFEs, and yesterday I addressed that in a podcast because now that's the best way for me to kind of communicate with people. That's why I'm telling people subscribe to that channel, the youtube.com/Shah-Pirali-Law. And what happens is for people who have day one CPT and for people who have multiple same level education, okay, what happens is that if you look at it, and we have been saying this before, the day one CPT is legal, okay? It's not illegal. However, it's legal only if to an exception. The exception is when it is part and parcel, it's an integral part of your curriculum. And many schools have been able to do that, and that's why people use day one CPT. Now, the second problem that we are having, and the RFEs are hitting hard on that, is multiple level of same level of education. What happens there if you have the same, for example, let's say you have a master's and you move to another master's degree and you take CPT, that's kind of quote unquote not good. So we're going to talk a little bit more about that in a few, but let me take one caller, Michael. Shah-Pirali, you're live on air. Hello.
Hello, good morning, Mr. Shah.
Good morning, sir.
Yeah, I have one question. So you see this on last month, the EB2 India priority date was March 2009, right? So now,
yes,
some people who has the priority date current that time, they are waiting for the green card right now. So, but now it retrograded, and so how it works? Is it like the USCIS is supposed to issue the green card to them, or
no? If the green card gets issued in the next 3 weeks before August 31st, yes, if they can process it. If not, then you go back and waiting list. But so if you are eligible to file for your adjustment of status, don't wait on that, file it. But it doesn't. It all depends how fast they process the case. So if they delay the case, then just too bad. You have to wait again.
Yeah, so still it's in their hand, right? I mean, they can.
Yeah,
right?
that's the unfair part of that whole thing. It's ridiculous, you know. But what can we do? I get irritated with it. I've been struggling with the visa bulletin since it started the biggest problem after they put perm, and that's when this. But it's always been like that. So let's say, for example, one document is missing, and they send an RFE. And you answer the RFE, and they have started processing. Let's say you answer the RFE on 29th of August. They start processing it at their leisure on September 1st. No matter what, they won't give it to you.
Okay.
So just pray that they process it in this month.
There is no RFE, but in that case, they usually issue in 3 weeks, right? That's the case?
Well, the green card, it all depends. If you clear the security check, then they will issue it. If not, they won't issue it.
Sure. Okay. Yeah.
That's their big secret, the security check. God knows what it is, and they just do it. But,
Thank you so much,
I can go on and on with this. It's so irritating. But hanging there, at least you got the EAD. You will be able to enjoy the EAD if you are able to file the adjustment.
That's the kind of you're right. Yeah. That's what you
yeah.
Yeah.
I'm sorry for that, but
Thank you.
we need to hang in there. Good luck to you, my friend. Okay, so ladies and gentlemen, this is the part which is the most frustrating, right? So this is the part which is most frustrating. Like the caller is saying, right, his dates become current. He filed the case, the adjustment of status, and then suddenly, by the time they go and process the case to issue the card, the dates get retrogressed. If the day the card is to be processed, the dates get retrogressed, they don't process the card. And that's the part which is very unfair. But I've seen cases where luckily people were able to get in. It's like jumping on those buses that had a lot of people in them, and you're like those trains. So hopefully some people will be able to, but most probably they will have to wait. Let me take another caller, Michael. This is, are you alive on here?
Hello. Hi, Shah. This is Mudit.
Hi, Mudit. How are you?
Good. I have a quick question on the new, so there's a new, I don't know if it's a law yet or notification from USCIS that if a green card holder is using some public money some way, then they will be denied. So I just wanted to check if FMLA or California SCFRA is included in that.
I don't know exactly what is included right now, but they say pretty much anything which is welfare, according quote unquote to them. For me, welfare is only food stamp, but now they want to include Obamacare. They want, because this is a proposition. It has not become. There's no memo yet on that, so I won't be able to tell you. But anything that they consider as welfare, unemployment is not considered welfare. Medicare might be considered if they want to use it. Medicare also. So, unfortunately, there's no way to tell until we see the final memo. And I did a quick video on that too a couple of days ago, but I will update it next week on the radio. Hopefully we'll have something, or hopefully there's nothing, because there's a lot of noise also, right? They make a lot of noise on certain things, but they are not able to pass it completely, so it comes back. Just like the H4EAD, they made a lot of noise, but then they were not able to really kind of craft something to take it back, so hopefully we keep that. But until then, it's very hard for me to tell you because I'm not aware of all the welfare list. But once I get it, I will let you know, okay?
But would you know that, so like anybody who has children here would be going through FMLA or those California state, would that be considered, in your opinion, would that be welfare?
Well, it's an insurance, right? So
yeah, it's an insurance. Yeah.
It's not going. Well, the problem is that if it is kind of similar to Obamacare, then yes, because he's targeting Obamacare too at the same time. It's like one stone, two birds, according to him, and that's one of those Miller's big prowess. I don't know how to call it. That this guy is coming up with all kinds of ideas to make people's life hard. But at the end of the day, yes, it might, unfortunately. But let us wait. Don't jump the gun, because that law might not even pass. So let's see if they will go through it. But they made a big announcement. They might, or it might not pass even muster of the court. So let's wait and see. Don't jump the gun. But yes, if it's insurance that is kind of a subsidized insurance, a bit like Obamacare, then it will be considered as welfare according to them. Okay.
Okay. Thank you.
Good luck to you. I know it's bad news too. So let me take. Before I take the other caller, remember there was this info that came out for people who basically kind of, if their case is denied, they will be placed on deportation. There was an update from USCIS, which I forgot to mention last week, and I think a caller mentioned it. They're putting this on hold until they can amend their guidance book. So until then, hopefully, this is kind of a little bit of good news and bad news, that they are not applying the law immediately of putting people immediately in deportation. So that's kind of helped a little bit. But having said that, they're still putting that memo is still in effect, and they can anytime amend it and put it and start using it. Let me take another caller. This is Shah. Hello.
Yeah. Hi, Mr. Shah. Thank you for the show. Yeah. So I had a question regarding the EB2 dates going backwards. You said it's 2003 right now, 2007. So doesn't the green cards get processed sequentially? What does it mean when it's so? Why wouldn't the 2003 holders already gotten a green card yet?
Okay, I'm a little bit confused, but what it means is that basically dates you will not be able to file adjustment of status, or if you have an adjustment of status file already, that means you will not get the green card. You will have your EAD, you will have to still wait. As for EB2 is 2000, it went back to 2007 in September. Not right now, it's in September 1st. And then for EB3, it goes back to 2003. That has been like that forever since they had the retrogression. So it goes backward from one to another. So that means you just have to wait until the dates become back current, then you will get your green card. If you get your green card before that, then you're okay, but if not, then you're stuck.
Okay, got it. Yeah, thank you so much.
Okay, good luck to you. Let me take another caller. Jai, you're home. Hello?
Yeah, this is Vijay.
Yes, Vijay, how are you?
Yeah, doing good, sir. So I have a question. Actually, I have an H1B in the year, I got an H1B in the year 2009. And I stayed I stayed in US till 2010. I went and back a couple of times, 1 or 2 times. I went back. And 2010, December, again I came, September, till 2011, Jan, 3 months I worked. And my mother passed away and then went back to India. So after, again, my visa was available till 2011, August. So I stayed only 1.5 years, less than 1.5 years in my 6-year duration. And then, so then actually now I came back on my B1 and then transferred my H1B. So requested for change of employer and then extension, change of status, and B1 extension also I did. It is under process. So the thing is, like, I got the receipt number and the premium processing. So the latest status, what they are telling is like, so I have submitted the client letter. After client worked in some company, and then I submitted all the details, RFC details, asked for client relationship, employer relationship, all the things I have submitted. So now the latest status is like, so they have denied my case because what they are telling is you have extended a 6 years period. So,
well, I have to look at the days because on the radio it's kind of hard. But technically, if any time when you are outside, the dates doesn't continue. So you can recapture that time, but it has to be explained in the petition itself. So if you use whatever time you have used, you have to subtract it from the 6 years. So if you have used only 3 years, you have 3 years left. If you have used it all, then you have nothing left unless you have an I-140 approved. But on the radio like that, it's going to be hard for me to kind of analyze. Give me a call at the office. We can do a consultation on that, 510-742-5887. And I might be able to see if I can revive your H-1B. It should be possible. It's only thing probably when you load your file, they didn't mention of recapturing the time. And that might be causing the problem. Because now they are just quick in denial. So you need to move fast before the B1, B2 expires. And if the B1 extension also is not there, then you will have a problem. But whatever way, you can always do it in a way like file it, get it approved, leave, and come back. But talk to me, call me at the office, let me calculate the date for you, and then I'll tell you
can you tell me your number once again, please?
Yeah, 510-742-5887. Okay?
Okay. Your goodness. Okay.
Thank you. Thank you so much. Good luck to you. Let me take another caller. This is Shaparali. You're live on air.
Hi, Shah. I recently got my I-140 approved, and I have a question regarding that. So the priority date they give, I want to understand that priority date will remain forever even if we leave USA, or how that works actually, or we have to be inside the USA with a job.
Okay. Well, very, very good question. Number one, it stays forever, provided 3 things. Number one, that your company doesn't cancel it within 6 months. Or number 2, there's no cancellation by the revocation by the USCIS based on fraud or misrepresentation. And number 3, there's no. Number 3 is basically no. It doesn't matter if you're staying in India. Your priority date stays with you, provided you meet the two first requirements, one of the two.
Oh, can you repeat the last one? First
okay, number one, the company has 6 months to cancel the I-140. So if they don't cancel it, you still keep it, okay?
So on what basis companies usually cancel? Sorry to interrupt you.
Yeah, but also I forgot to mention that the priority date, if you only the priority date you want, it doesn't matter they cancel the I-140 because the priority date will stay with you. The only time the priority date will go away if in case there is some kind of fraud or misrepresentation, that means there was some lie on the case, then the USCIS take away the I-140 with the priority date. So I correct that. So the priority date stays with you even the I-140 is canceled, okay? So but unless it is revoked by USCIS themselves.
Got it. So after, let's say after 10 years, it becomes the current date. So that time any other company can apply on that priority date?
They can use the priority date, but they have to start over with the labor, etc. But yes,
I see. Okay.
They can use the same priority date, yes.
Okay, got it. And what is the wait period for right now? Some people are saying like 130 years, 250 years and stuff like that. So
EB2, no, it's not 250 years. But I think it's more realistic, maybe 15 to 20 years, yes. There is a chance. But you never know with those visa bulletin. You might see suddenly a jump in it. And we have seen that 2-3 times in my career. One time in 2007, and then 2010, and then 2012 also. It keeps jumping. So it's not fixed. But right now, if it goes like that, we're talking 15 to 20 years.
So how much usually it jumps?
It doesn't. There's no pattern for it. It can just jump, become current. One time it jumped, it became current. But it doesn't jump that much lately. It has not jumped. Suddenly you might see it go 3 years ahead. And suddenly you might see it go 3 years backward. And that's what it just did, 2 years backward. So there's no way to really predict that. There's no real way to predict it.
Okay. And can I apply EAD?
No, you won't get an EAD unless the adjustment of status become current. So until the dates become current. We had the second chart that was allowing people to file at least to get the EAD, but they are not honoring it completely. So until they give us the go, because the visa bulletin is issued by the State Department, and the DHS is the one that takes the application. And it seems like DHS is not really accepting the second chart, where even the dates are good, you're still stuck. So right now, you won't get an EAD until one of the charts, or they accept the second chart to file for the EAD. So right now the second chart is May 2009. So let's see if they will accept that. But you won't get the EAD unless you're still with the company, and plus the dates become current. It's a little bit tricky, okay?
Oh, so I cannot apply EAD for now as per the information that you shared. I should wait for further notification.
No. You can apply for EAD if your dates are current. What is your priority date?
Oh, my priority date is like January 2018, this year.
No, you cannot. You can apply. Okay. There is one EAD under extraordinary circumstances, but I have never applied one. This is only if you have some really, really major problems, okay? But now you can try that.
I'm talking about the H4 EAD. Is that the one?
No. H4 EAD is different. Yes, you can apply for H4 EAD. I was talking about the adjustment of status. I'm sorry.
Oh, no. I was talking about H4 EAD. Sorry.
Yeah, it's open. I'm sorry for that. H4 EAD is open. Okay?
Yeah. Okay, I'll apply for that. Okay, thank you very much.
If you need help on the H4 EAD, give us a call, 510-742-5887. I apologize for the misunderstanding. Okay,
sure, no problem. Thank you very much for the information, Shah.
You're welcome. Let me take another caller, Michael. Hello, this is Shah. You're live on air.
Hi, Shah. Good morning. One of my friends recently got employer laid off a group. So he got a termination notice from his company. And on the letter, there are two dates. One is the termination date, and the other one is the end of severance package date. So So my question is, from which date does the 60-day grace period start for H-1B?
Termination date. Termination
date. Okay. And is there any
severance has no? You cannot use a severance. In fact, there was a case law that came out. I forgot that case, which says severance date doesn't count. It's just a severance.
Okay. I see. And is there any way to extend the termination date? Because generally companies issue like a 2 weeks notice at most.
That's up to the company. Because the problem is that even the company extend, it depends what they write to the USCIS, right? Let's say, for example, you talk to your company, they say, oh, we'll terminate you on end of October, but then when they send a letter to USCIS, they put September.
Mm-hmm.
That's also I have seen, and that's the problem. So if they want to extend it, it's internal. Just make sure when they send the letter, they put that date of October, not September, okay?
Okay. And his spouse is on H1, so would you recommend that he should probably start the process for converting himself to H4?
Yes. What I recommend is to have the H4 EAD and H4 or H4 EAD, one of or both, to be filed ASAP, and then you're still okay to file your H1B. The advantage of having the H4 EAD file within the 60 days is that if in case there's no H1B or H1B gets denied, he still will be legal here after the 60 days based on a period of stay authorized by an authorized period of stay, which allows him him or her to stay in the United States without being fear of deportation. So it is recommended to do it in parallel, and if they need help on that, just give me a call, okay?
Okay, sounds good. Thanks a lot.
Good luck to you. Yeah. Good luck to you. So, ladies and gentlemen, this is Attorney Sharper Ali, and we were talking, of course, we had so callers, so I wanted to thank you all. Thank Michael for helping me. And just to let people know, anything I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. We still have 10 or 12 more minutes to go, so please feel free to call 510-657-1170, 510-657-1170. One correction, I think a couple of shows ago, someone asked me when the dates of the extension, if you have an EAD and you're filing the case and they give you another 180 days, when does the 180 days run? From what I've kind of gathered, it starts running from the date the previous EAD expires, not from the date of application. So I stand corrected on that just to make sure I told the person I was going to mention that. So the 180 days extension, if you get it on the receipt, it starts from the date the actual EAD expiring, okay? So let me take another caller. This is Sharpara, you're live on air.
Yeah, hi. My name is Rahul, and I have a question. So I have a I-140 approved, and my priority date is April 2013, and I'm planning to move out of United States. So let's say 10 years later, if my date gets current and I get a H1 here and a job back here, can I use the same priority date later on, 10 years later?
Yes. I just answered that question earlier. I don't know if you heard me, but yes, you can use it provided two things. Number one, it has not, one thing which is the most important, it has not been revoked by the USCIS for fraud or misrepresentation. If it has not been revoked, yes, you can use it without any problem. So you can use it, but remember, you can only use it if either you can use it with the same company if the company wants you back to work for them, or you will have to file a new labor and a new I-140 with another company and take that priority date and put it there, okay?
Okay, thank you.
Good luck to you. Okay, so that's one thing that I'm hearing a lot now. A lot of people trying to move back because they're getting tired of the waiting, so it's better if they move there and they work remotely. And that's going to hurt the U.S. Definitely. A lot of good people moving out, not only in terms of the IT sector, but everything else will be affected. Just like for people from Mexico when they start basically cracking down, a lot of businesses got affected. And not only that, it's going to have a domino effect, as we call it. That means basically if nobody's in the Bay Area, you won't have shops selling certain products. And if they don't have shops, those people will not have, people working there will have no jobs. And people having no jobs, it will have, then you are going to see house market go down. And those are stuff that we are worried about coming up soon, because especially in the Bay Area, California, things might get not very kind of difficult for a lot of people. But at the end of the day, let's hope things will get better. But I think it's going to get worse, like I said before it gets better. So I don't know. I don't know, Michael, if we have how much time we are left and if we have any callers. But the lines are still open, 510-657-1170. But before I close, I wanted to talk about debt settlement, because this is another service we offer, especially for people moving out. They have a lot of credit card debts and things like that, and suddenly they find themselves not able to pay those debts. And instead of having it on their credit because they're planning to come back maybe 5 years, 10 years later, we can clear those debts without them going to a bankruptcy. And this is what we call debt settlement. And they can read a little bit more about it, yourdebtsettlementattorney.com. And you can call us if you need help on that, 510-742-5887. We can do it for credit cards. We can do it for second mortgages in some cases if the house is losing value. We can do it for basically judgments against you. For example, let's say you were sued and you owe money, and it's not necessary that you have to leave the country. We can fight. We can still fight when you're here. It all depends on your hardship. Hardship is very important. It means how difficult is the situation for you, and you have to deal with that. So this is where we can help you. Give us a call, 510-742-5887, 510-742-5887. And the website for debt settlement or the blog is yourdebtsettlementattorney.com, yourdebtsettlementattorney.com. So, ladies and gentlemen, let me go back to immigration now, because we are talking about this September visa bulletin, and it's going to have a huge psychological and physical impact on people. For one, people who are current and file their case, if their case is not processed on time, that means another waiting time for them. And we are hoping the priority date might jump back probably around October. Now I'm going to get into some forecast or prediction or whatever you want to call it. And again, anything I'm telling you is just my opinion here, okay? So my take on it is that I'm hoping by October, on the new fiscal year, we're going to see a move under the EB1, a move forward, probably bringing it either current or to 2014. So if you're eligible for EB1, and you can check, don't go by the checklist. Like Sharif was saying last week, forget about the checklist. Let us assess your case on an EB1, because if you qualify for EB1, a lot of headache will be gone. When we file the EB1 for you, not only we can file it, we can still take the old priority date you had on EB2 or EB3 and put it in there, and ultimately get you a green card if the dates are current. Right now, EB1 is 2012, and September it will be 2012. And let me give the exact. It will be 2012 January for India. And for those not born in India, of course, this problem is not there because it's current. So we will be glad to kind of help you in getting an EB1. We had some very, very good success rate when it comes to EB1. So check a little bit our reviews, etc., and you will see the kind of things we have done. And EB1 is the way to go now. You can have EB1A, which are for people of extraordinary abilities. You don't need an employer for EB1A, by the way. EB1B, scientists or outstanding scientists and researchers, and that one you need an employer. And number 3, EB1C, are for those people who go. For example, let's say you go back to India. You work there for 1 year for a branch of your company. You can, if they bring you back here, you can file for the EB1C and actually take that old priority date and push it there. EB1C is usually kind of the L1A, but you don't have to be an L1A, by the way. I repeat that. You don't have to be an L1A to file for EB1C. So it is very important that you know how it works. And in order to evaluate that, give us a call, 510-742-5887. We are doing a lot of EB1 right now, and luckily we are getting a very high success rate, almost, I don't want to say the 100%, but it's close there. And if you need any help, just give us a call. I think I'll take one last caller, Michael. This is Ray, you're live on air.
Yeah, I would like to know, I'm on H1, I'm on B1 visa. I heard on the radio talking about EB1 and all. I would like to know the entire process. If you have time, could you please elaborate on that? Like how, after applying, what happens and things like that?
Okay, EB1 is applied direct. There's no labor certification if you qualify for it. You file it directly, but it's not, EB1 is not like other applications. It's not like you fill in a form, you'll get it. It requires a lot of legal writing and a lot of analysis. And if it goes through, the I-140 is approved, it has a different priority date. And if your dates are current, or if you're not born in India, the dates are current, you can file adjustment of status and get your green card. For many people outside India, to get the EB1C within 2-3 weeks after we file it with the premium filing. So EB1A is one, then you have EB1B. The process is pretty much the same. There's no labor certification. It's filed directly. And the best way to kind of, we talk about it, and I have my YouTube, on the YouTube channel, we have some very good explanation on EB1, so I will recommend refer to that. And I think I lost the caller. So, Deepa, please give us a call, 510-742-5887 if you want us to evaluate your EB1. Then there's National Interest Waiver. Although National Interest Waiver is an EB2 category, I still recommend it to people because if you do qualify for it, the advantage with the National Interest Waiver, for example, let's say you file a National Interest Waiver. The dates are not current, of course. But let's say you want to go back to India. Let's say 5 years down the road or 10 years down the road, the dates become current. You can just use that. You don't have to transfer it to any employer because you don't need an employer to file a National Interest Waiver. And if you're not from India, you're from another country, you might even be able to file a green card adjustment of status together with it. There's no premium processing, by the way, for National Interest Waiver, but we are doing a lot of them too, and especially I have a lot of clients from different places, from Europe, Japan, not really China, but from South America, from Canada, who qualify for it, from Pakistan also, from Egypt, who do qualify for National Interest Waiver. You should look into that. The other thing that I recommend people to do is that a E2 visa, if you have a citizenship of certain countries who qualify on that, if you want to come to the U.S., please feel free to check the E2 visa. I actually kind of put some stuff on that. I'm going to upload it. And I have a Facebook page, USA Investor Visa. Like that page, and I will put updates on that. And now the other thing people are asking are EB5. I don't trust EB5, so I'm not going to discuss too much about it. But it is available for $1,500,000 investment, depending on the project. So all those things are available. It's not only the H-1B. And the main thing I was talking about earlier when we started, the day one CPT, avoid that as much as possible. It's becoming a big headache, and I was expecting it was going to become a big headache, and it does now. So be careful when you're using it. And also, when you're using a day one CPT, if you, for example, you have a master's degree, you're taking a second master's to get a CPT, it's a no-no. Usually you have to upgrade it one notch or one step ahead before you use that. So be careful if you have used that, because that combined with the memo that came out on student visas out of status situation of the DS, you might see yourself suddenly out of status without even knowing it. So be very careful. All those things are going to hit home soon, and it's already hitting home. Now, the other thing that I wanted to mention, which I forgot last week, is that the memo basically of deportation automatically has been delayed a little bit. Not the memo itself, but the implementation of it has been delayed. So hopefully it gets delayed forever so that people doesn't go into deportation automatically when they denial. The other thing on the updates people are asking is the H4 EAD. The H4 EAD itself, we don't hear anything, so it's no news, good news, kind of. So people are still eligible to file for it, and I recommend people who want to take advantage of it, because I'm hoping for those who already have it, they won't take it away. And the other good news is that DACA seems to be coming back. It seems like the Trump administration was not able to kick it out completely. So hopefully based on that, H4 EAD will have the same fate, and they won't be able to take out the H4 EAD. And watch out for no RFEs coming soon after September. And the memo for students going out of status kicked in yesterday, so watch out for that too. If you have any kind of violation, I recommend that you check with an attorney. And if you want a second opinion on your case, or if you have an RFE you need us to answer, just to let you know, just because you have one lawyer, you can always shift if your company agrees with that. So give us a call, 510-742-5887. Check our website, attorneyonair.com, and Michael is giving me the sign that the show is finishing now, and I'm going to sign off. I just wanted to say